Hi, everybody. This is Kathy, the second impromptu live of today, and today is the 28th of February, 2026, here in the United States. We'd done a live earlier this date and went over 3 federal court matters. The third is an extremely important case that is coming up for oral argument Tuesday, March 3rd, 2026 at 10 o'clock a.m. It will be at the Supreme Court of the United States in Washington, D.C. This oral argument, which is scheduled, is on a case called Hunter versus United States, and it indirectly relates to cases like Idaho versus Kohberger. And the issue before the Supreme Court of the United States in this case, one of the few that they accept on appeal. There are thousands and thousands and thousands of cases that try to be heard by the U.S. Supreme Court, and most, but a trickle, a handful, are denied. Hunter versus United States is asking the Supreme Court to look at appellate waivers when parties like Mr. Hunter and Mr. Kohberger, amongst others, enter into a plea deal after being charged and prosecuted for crimes, agreeing to give up their constitutional rights to remain silent, to be able to confront accusers at trial, for the right to due process, which includes a mandatory requirement of an impartial, fair judge and jury, and the right to a public trial where the public can bear witness to everything to ensure that our court systems are operating as they should be, and that judges don't act like kings or queens. That's the reason why our country separated from England, as it did back in the 1700s, that prosecutors and law enforcement do not abuse the enormous power that they have over people's lives and liberty. And that I would also argue that defense counsel operate as they should be as well. When cases like Idaho versus Kohberger are prosecuted, as this case was, largely under seal for the more than 2.5 years that it proceeded, first in Latah County, Idaho, and then in Ada County, Idaho, on top of a airtight gag order, which prevented any updates to the public, as you see in other cases many, many times. Law enforcement, prosecutor, or defense counsel might give an occasional interview, might send out a press release, might hold a press conference. You saw none of that in Idaho versus Kohberger because of the gag order that was in place from day 4 in the case, on top of the hearing after hearing after hearings that were held in secret, behind closed doors. In some cases, the public didn't even have notification that these hearings were being held. That's not how our country was set up. Our country was set up that anyone should be able to go into any courtroom in the United States, state or federal, and watch proceedings, bear witness, and ensure that what the framers of the Constitution, as demanded by the 13 original colonies that then became the states, wanted this country to operate at, which is with transparency, which is with openness, which is with judges who don't act like they're kings and queens, that act as though they're public servants, because that's what they are. Same with prosecutors and same with law enforcement. Now, welcome, Joseph. Welcome, Dan. So glad to see you here today. Everyone, please, if you want to join us in chat, please do. And be sure to hit the like button. Okay, so what is the connection between Hunter versus United States? This case that is one of the few that made its way successfully to the Supreme Court of the United States. Mr. Hunter, Munson P. Hunter III, he was the defendant who was charged with crimes in a federal court in Texas. And he was supposed to stand trial, as Mr. Kohberger was, across the country in Idaho. And what happened in both cases is that both defendants signed plea agreements, which meant that they gave up any possibility for appeal, which I personally feel is against public policy on many, many levels. But they did. Both were sentenced to go and serve their incarceration period. In Mr. Hunter's case, he was charged with financial crimes. And he wanted to appeal his sentence, and he did appeal it to the Fifth Circuit Court of Appeals, that is over Texas. And you know what happened? His appeal got dismissed by the appellate court. You know why? Because of that plea deal. Because he had signed away his opportunity to ever have a higher court. Look at what happened at the trial court level. Same exact situation as with Mr. Kohberger. Hello to Tina. Tina, I'm so glad you're here. I'm so glad that you're here with us. And Jor, thank you. Thank you. So just to bring everyone up to speed, we're going over this really important case that's coming up on Tuesday that I think needs a lot more publicity. We have been covering this case for some time. I have a playlist where I've gone over all of the filings in the Supreme Court, and that's Hunter, and I provided a link in the description to this podcast episode. And I've also provided a link so you can go directly on the Supreme Court's website and see all of these filings for yourself. But just briefly, Mr. Hunter signed a waiver of appellate rights. This means he gave up all of his rights to appeal, just as Mr. Kohberger did right before change of plea last year in July. Both of these defendants agreed that in exchange for what the state in Mr. Kohberger's case and what the federal government in Mr. Hunter's case was giving to them, that they would agree this would be it. There would be no waiver. There would be no appeals. It would be done. This was it. Mr. Hunter tried to appeal his sentence. Fifth Circuit Court of Appeal dismissed his matter, said, hey, Exhibit A, you signed this plea deal. We can't look at your case. So what he did is last April 9th, at about the time that Mr. Kohberger was getting ready to go into Judge Stephen J. Hippler's courtroom for a full day of hearings. This was, if you've been following the case for a while, this was the motions to suppress, motions in limine hearings. It went from early in the morning until late at night. There were multiple motions to suppress. And this had to do, motion in limine is a motion pre-trial, and what the state and the defense were arguing that day in front of Judge Stephen J. Hippler was that certain evidence should not be admitted into the forthcoming trial, because remember, Back on April 9th, there still was a trial that was supposed to happen in Idaho versus Kohberger, and that was supposed to happen in August. So you had the state coming forward with a motion in limine asking for a court order. Oh, excuse me. Asking for a court order pretrial to have certain things admitted into evidence, like the text messages that were just unsealed a couple of days ago. That was a state motion in limine. The defense opposed that motion in limine, finding that this was hearsay, it was prejudicial, it was improper. Judge, it should not be allowed in the case. That was one motion in limine. There were multiple others. What did they cover? Everything from motion in limine regarding the admissibility or inadmissibility of CSLI evidence, one of the most hotly contested items in the entire case. Motion in limine as to the admissibility or non-admissibility of evidence concerning suspect vehicle 1. One of the things noted in the affidavit of probable cause that led to Mr. Kohberger's arrest. Motion in limine regarding witness identification by bushy eyebrows was what one of the surviving roommates testified that she saw that day, November 13th, 2022. Admissible? Was it unreliable? Should it be brought in before the jury or kept out of the jury? Motion in limine regarding IgG DNA evidence. Ladies and gentlemen, if you followed the case, then you know that this was one of the most hotly contested case from the beginning of the case. There was requests for discovery regarding the DNA evidence allegedly found on that sheath at the crime scene. Motions to compel. There were hearings behind closed doors. There was an order that Judge John Judge put out. Finally, at the end of 2023, after much back and forth, this is what you're entitled to receive defense. You're not entitled to receive everything. And oh, by the way, you can't share it with people. You've got to ensure that this is kept securely under lock and key. The battle over this evidence, IgG DNA, went on into 2024. And then it turned up in an in limine filing in February of 2025. Other motions in limine dealt with Amazon click history. What did the state say that they had in their public filings? They said that they had ironclad evidence that Mr. Kohberger purchased a K-bar, a sheath, and a sharpener from Amazon. And that's the evidence that they would be able to put on at trial. A lot of these filings are still under seal, the evidence portion of it. What was released to the public a couple of days ago was the defense's opposition to the in limine filing of the state regarding text messages. And that's the first time that the public saw text messages that went back and forth inside of 1122 King Road, that went from 1122 King Road outside of the house, and was from outside of the house that came into the house. First time that was seen. But Judge Hippler signed an order back on December 18th that motion in limine regarding text messages were to be released to the public, along with dozens upon dozens upon dozens of other evidence under seal from the in limine, amongst other filings from March, April, and from January, February, March of 2025. With the exception of that one filing that came out 2 days ago, everything else is still under seal. This case is approximately 95% still under seal. And I, for one, am having a very difficult time understanding, number one, why this case was so sealed during the more than 2.5 years that it proceeded. And now for almost 8 months since Mr. Kohberger pled guilty. There's never been a hint of another co-conspirator, alleged alternative perpetrators. No hint that there's an alternative perpetrator out there. As a matter of fact, the state fought very hard to keep Mr. Kohberger from entering any evidence at trial of an alternative perpetrator. No hint of a conspiracy, no hint of an accessory before the fact or after the fact. So if, per the state of Idaho at this time, 3.5 years after these crimes were committed, why is this case still under seal? If, per the state of Idaho, one person and one person only was responsible for these crimes, why is this case still under seal? Why was it under seal with all of these secret hearings and with this gag order when cases are supposed to be prosecuted in the public, in the sunshine? What was so different about this case? It is an unfortunate but a true fact that unalivings and sometimes mass unalivings happen regularly, as much as we don't want to think about it, but they do in the United States. And there are trials, pre-trials, that are not sealed like this one was, and certainly not continued to be sealed after the case is quote unquote closed. Is this the precedent that we want to set in this country? Is another concern that I've had all along. If he's the only one who did all of this damage, why is the case still hidden from the public? And while it's true that there have been documents that have come out from the Idaho State Police didn't prosecute Mr. Kohberger. And while it's true that other documents have come out from the Moscow Police Department didn't prosecute Mr. Kohberger. It's the documents in the court filings that matter. And that's where my concern is. All of this time has passed, and there's been almost a complete standstill to unsealing of this case, with more and more and more and more documents being sealed, up to and including the last two that were filed in January and February. 3 documents, actually. Everything's under seal. Why? The issue of Mr. Kohberger and how this case was prosecuted has been a concern to a lot of people. I'm very proud of the people that follow my channel a lot, whether it's over on Spotify or any other of the podcasts where the Idaho versus Kohberger podcast populates to, including here on YouTube. And I recommend that if you want to look at that podcast, what I did is I went back, it goes back from the beginning of the case, and we have curated the entire docket, looked at documents that were on the public record, looked at documents that were under seal, and in 5 minutes or less, cut to the chase, put in a couple of terms to cut through the legalese, and showed you where you can find it on the docket. Because I believe that everyone who has followed me on this YouTube channel or on my podcast was perfectly capable of being named as a member of the Kohberger jury at the trial that never happened. And so I'm very familiar with that docket. I know it like the back of my hand. And I put out content after content, another item under seal. Oh, here we go. Order sealing yet more evidence from the public. Now we found out that a hearing was held a week ago. It was never even noticed on the court docket. I called it a Mount Everest of documents under seal, and 95% of them are still under seal. Now, getting back to, I just want to say hello to a few more people. Hey, Carrie, good to see you. Thank you very much. Hey, Legendary, very happy that you're back. Thank you for being here today. Tina, thank you also for being here. You're one of the reasons, Tina, why I decided to do a second live today, because I was getting notification that people didn't know we did a live earlier today and had questions. And so you're one of the reasons why. I got some feedback also for some other people, but you're one of the main reasons why we decided to do a second live. I think that Hunter versus United States merits it. It's an important case. Why? What is the connection between Mr. Hunter and Mr. Kohberger? We've talked about the fact that both of them waived appellate rights. That meant that when they signed their deals with the government, they agreed that they would not appeal. April 9th of last year is when Mr. Hunter filed his paperwork for consideration in the United States Supreme Court. And his position is that there should be more reasons than the two that appear to be in agreement across this country. There's a split in the appellate courts. There's disagreement of what, for example, Garza versus Idaho stands for. If you watched the change of plea hearing, when the court went over that contract, supposedly, that Mr. Kohberger signed of his own free will and volition, he made a comment that, yes, see that you waived your appeal rights, words to these effect, but we all know that it's not final. And he was directly reciting to Garza. Garza is a 2019 United States Supreme Court case. It is in the first filings in the petition for writ of certiorari. That is the appeal paper that Mr. Hunter filed April 9th at about the time that Mr. Kohberger was getting ready to go into Judge Stephen J. Hippler's courtroom for that marathon day of hearings on the motions in limine, oral argument, most of which are still under seal from the public. Mr. Hunter filed his petition, and he wants to know, are there more reasons that someone can bypass an appellate waiver in a plea agreement other than the two that are recognized across the country? One is ineffective assistance of counsel. You would have to show that your counsel did you wrong, led you the wrong way, promised you something that you thought you were going to get, didn't explain things to you, betrayed you, didn't do what counsel was supposed to do in a case. I would argue this would be a very difficult burden. Mr. Kohberger has not shown, he's no indication he's appealing anything, but we're talking down the line. And what the reality is for him right now, and will be down the line unless there's some change at a national level, he would have to show, one, ineffective assistance of counsel. I would argue that would be a difficult argument to make, because everything that he has shown thus far is he is perfectly happy with the defense team that represented him. All three of them were at that virtual hearing. He was not in November, where the prosecution was seeking more from him for certain of the families of the victims. Mr. Kohberger, that was the first time that I can recall from the beginning of the case that he didn't participate in a hearing, that he was not at least present. But who was present was Ms. Taylor and his other two defense counsel, the same three people that were at the table with him at change of plea and also at sentencing on July 23rd, 2025. Same three people. Also, Ms. Taylor has been filing documents regarding the unsealing of this case. So it sounds to me, 8 months after the case was supposedly closed, that he's not unhappy with their representation. Again, my opinion only. The second grounds that's recognized throughout the country is that the judge sentenced the person to more than whatever the statute prohibiting the crime authorized. For example, Mr. Kohberger, count one. Who knows what count one of the indictment? The indictment was what the document, and Judge Hippler read from that indictment. It was returned by the Latah County Grand Jury, May of 2023. It indicted him on 5 felonies. Who remembers what count one was? Hey, we have, someone from the Philippines. Wow, so happy that you're here. Just take my time. Thank you. A territory of the United States. Very glad to see you. You know, my first follower from my podcast when I first started doing the Idaho versus Kohberger podcast was from Japan. Far East, from Japan. Now, the Philippines is a territory of the U.S., But it's incredible the global interest that this case has had. And I'm glad wherever you are, thank you very much for taking time out of your day to be here with us today for our second live of the day, focusing on Hunter versus U.S. and the connection, important connection to Idaho versus Kohberger. Some of the contacts that we have here, Jerain is saying nothing should be under seal at this point. A lot of people feel the same way you do. I have thought about this for a long time. I've thought about it on my own. I've questioned. We've had conversations with other people. And I'm at a stump. I'm at a loss as to why Idaho versus Kohberger is 95% under seal 8 months after the sole person who was ever charged with anything having to do with the crime stood up in open court and pled guilty. Not kidding. You're close. Jurors close. It's the burglary count. Count 1 was burglary. Count 2, 3, 4, and 5 were for the unaliving counts. Count 1, Mr. Kohberger was sentenced to which was 10 years in prison for the burglary. Now, why the burglary charge come first? Some would say because he would have to enter the premises with the intent to commit another felony. That's what the burglary charge says. And then the unalivings were count 2, Madison, count 3, Kaylee, count 4, Zana, count 5, Ethan. I have always wondered if that was the sequence of the unalivings. But in any event, the second thing he would have to show in order to get a possibility for a new trial, which is what you appeal for, there is a sentence that says you're going to be in prison for 10 years as to count 1, and then for your lifetime, count 2, for your lifetime, count 3, for your lifetime, count 4, and for your lifetime, count 5. And that's where he's been since July 23rd, 2025. Ada County didn't waste any time. The judge says you will go immediately. He left, not the next day, but that afternoon. After sentencing, he was taken immediately to the state prison in Boise. And that's where he's been ever since. So it appears that Judge Hippler did not go over. I mean, on the unaliving counts, he was looking, it was a capital case. He was looking at the ultimate penalty, right? So what Hunter is saying is that people like me who have signed a waiver of appellate rights, shouldn't there be other grounds? And he is talking in terms of due process, and due process requires a fair and impartial judge. How many of you feel that Mr. Kohberger had a fair and impartial judge? How many of you feel that Mr. Kohberger did not have a fair and impartial judge? I'd like to hear from you, because that may be one of the things that, depending on how SCOTUS rules, and there's no guarantee that they're going to do anything except keep things as they are right now. But Mr. Hunter and a lot of good people who have filed amicus briefs want that changed. Just Wasting is saying you believe that Mr. Kohberger is innocent. You would be, have you read any of the filings from Hunter versus United States? Just wasting my time. Or have you looked at our playlist? One of the amicus briefs, now this is a brief, a friend of the court, someone who doesn't have any relationship to Mr. Hunter or any relationship to the United States. Completely impartial. But they have an opinion as to how the court should rule on this matter. And one of the amicus briefs that was filed in Hunter versus United States is from a person who was head of a law school in the East Coast and has done work including scientific research on whether people who are innocent plead guilty, because I think that if you feel that Mr. Kohberger got a raw deal, and I think 50% of you feel that way, 50% of you don't. But if you feel that he got a raw deal, sometimes you may be told, but he pled guilty, and he did. There's no getting around. He stood up in open court. You saw it. I saw it. July 2nd, 2022. And he told Judge Stephen J. Hippler, he told his family members that were in the courtroom that day, and he told the world, yes, 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 and yes. When Hippler went down the indictment and asked him if he was guilty. No getting away from that. That happened. That's a fact. But the amicus brief, one of them that's filed in Hunter versus United States, says that there is scientific research that people will plead guilty. That they will plead guilty even when they are factually innocent. They get scared. They get concerned about what the potential penalty could be of what they're facing. Now, these weren't criminal defendants. This was as close as this college and this researcher could get. It was a group that were told, hey, if you plead guilty to something that you didn't do, you'll get a reduced sentence. And that was filed by the Plea Bargaining Institute. There were other amicus briefs that are sitting in the Supreme Court case of Hunter versus United States that says that far too many people that are poor and who are given public defenders, some that may not be very experienced, they plead guilty whether they're guilty or not guilty. There's another amicus brief that says that this is against public policy, that there should always be an opportunity for someone to have a higher court take a look at what happened in the case below. There's another that says, a lot of times what they'll, hey, this is a contract. You know, we agreed to give you this and you agreed to do this. This is a contract like any other contract. And what one of the amicus briefs says, oh, no, it's not. This isn't like a contract to buy a house. It's not a contract to rent a home on the beach for a week. This is a contract dealing with a person's constitutional rights. It should not be looked at as a contract. Rachel is here, and she's saying, I don't think Judge Hippler was already convinced BK was guilty. Thank you for your comment. I appreciate it. Just wasting my time feels that Hippler was lazy. Very disappointed in the U.S. justice system. George Arain is saying it's ironic that Kohberger is actually studying the reasons as to why people make plea deals, even when innocent. Let's get back to a couple more of the appellate briefs. And again, I have a playlist that's in the description to this podcast episode that you can listen to that will give you the nuts and bolts and will tell you exactly where on that docket you can find the entire study. Another one of the amicus briefs say that these plea deals should not be behind closed doors, but they are. It's the state or the federal government and the defense negotiating about someone's constitutional rights behind closed doors. And when I read that, I said, oh boy, do we have a case for you. It's not just that the plea agreement was behind closed doors. It was the entire case was virtually behind closed doors by virtue of what I have called the Mount Everest of documents that were filed under seal, including evidence of why the state of Idaho felt that this person and this person only was guilty of the 5 crimes, all felonies he was charged with, beyond a reasonable doubt evidentiary standard. That is a high standard that a state or a government has to prove. You have to have a lot of evidence. It needs to be admissible evidence. And we still don't know what that is, even at this time. And what one of the amicus briefs talks about is plea deals or behind closed doors. The public wasn't present when suddenly, and this seemed to happen like in a blink of an eye, one day they're doing what they did for the more than 2.5 years beforehand. They're fighting tooth and nail. I mean, I recall the defense standing up in open court one time and saying, Mr. Kohberger is not just not guilty, he is factually innocent. Defense attorneys don't do that. They do not put their neck out on the line and say their client is innocent. That was very, very rare. That happened in Latah County. All right, so for more than 2.5 years, defense, you fought tooth and nail in this case. You said at one point he was factually innocent. And state, you said you would never enter into a plea. You were going to take this to trial because this was a DP case. So how in the heck did we go from that position in literally mid-June? In mid-June, third week of June, both sides were preparing for jury selection, which was going to be happening in just a matter of weeks. In that case, in July, all of a sudden, here's the plea deal signed June 30th. Where did that come from? How did that happen? What one of the amicus briefs is saying, those types of negotiations need to happen in the public domain, not in secret, on top of this super secret case that still is sealed. So George saying just knowing that there was unknown DNA on that sheath was never located is so suspect to me. Why wouldn't they test that? It seems the logical thing to do. You know, people have been bringing up so many points, great points. No one more than me put out content on that sheath, because once we started to get the records unsealed, especially from the Idaho State Police, telling us, and also from Moscow Police Department, telling us about the chain of custody of that sheath, I said that sheath should have been thrown out just on suspicion that there was a break in chain of custody. For one thing, people think that that sheath was immediately brought to a Meridian, to the Idaho State Police Lab on November 13th. No, it was not. It remained in Moscow for 3 days at a time when the Moscow evidence tech was on vacation and the person that was backfilling seemed to have some problems, had to call ISP seeking help. It wasn't until Wednesday, the 16th, that sheath left the Moscow Police Department. And when it left the Moscow Police Department, it was in what I like to call, it was in a paper bag, like a peanut butter and jelly sandwich someone might make for lunch, is thrown in there, all casual. Not the key evidence of a multi-unaliving case. There was no evidence tape on it. There were no initials on it. And you do those things to secure the integrity, to prove at trial that this item of evidence is the exact one that was located at 1122 King Road on that third floor. And then we saw some photographs, didn't we? We saw some photographs that ISP took of that sheath. It was the first time that we saw it at 1122 King Road, but it wasn't the photographs that were taken immediately when those first responders got there. Every one of those first responders went up into that room. There were 5 of them, and exactly 0 of them mentioned seeing a sheath at 12 o'clock, at 12:05, at 12:10 p.m. Because recall that the crimes allegedly happened sometime between 4:07 and 4:20 a.m., the call for help didn't go out until 11:56 a.m. So those first responders, they were the first ones in that room. Why didn't any of their reports talk about the sheath? And then we have Officer Snyder. He took almost 200 photographs, many of them in that tiny, tiny room, up close. Why doesn't he have 20 photographs with the title sheath from the left, sheath from the right, sheath from overhead, sheath from below, sheath is seen from the door, sheath is seen from the window, close up of the sheath, farther away of the sheath from the hallway. There should have been multiple pictures of that sheath. It doesn't describe one. Now, do they exist? Possibly, but guess what? The public won't see them because of the injunction that was placed on the issuance of those photos by Judge Marshall. Right? Remember the case? In the fall of 2025? So how is the public supposed to ever see a photo? Most people don't want to see the victims. They want to see that sheath. I certainly do. But you know what? I've got a long playlist. I've got a lot of content. It's called 3 Days in Moscow. And I go over and I pinpoint to the record, as I do, all of my evidence. And you know what it means? Absolutely zero. It's a point of discussion, as is all of the discussion of DNA, is the 911 call authentic, not authentic? Are there people that are seen around the house? Was there evidence of a clean? It doesn't matter. It doesn't matter. It's discussion only. It is discussion only. And I think it's important discussion because it keeps this case in the public domain. But the bottom line, if the objective is to hope that Mr. Kohberger will get a new trial, I would argue find one case where someone pled guilty in a DP case and was able to get a new trial. They have to show ineffective assistance of counsel or that they were sentenced wrong. They were sentenced to more time. When they say he will spend the rest of his life in prison, they're not saying that without a bite behind it. That is, unless something changes, he will be in prison the rest of his life. That sentence needs to be set aside. And if the objective is to get him a new trial, or the governor of the state of Idaho, because this is an Idaho, this is a state conviction, would have to pardon him. And I don't see that happening. Hey, Blueberry, good to see you. Good to see you back. That's why this case of Hunter versus U.S. is so important. Hunter's looking, and the people that are behind Hunter that filed these Amici briefs, they want to put a stop to these plea deals. In my opinion, I'm absolutely against it. I think it violates public policy, and I agree with what the Amici are saying in their briefs. Their briefs were sent to the United States Supreme Court, and when the one was sent saying, hey, I'm the person who did this study with my partner, and we're showing that majority of people who are innocent of something will plead guilty, and here are the factors, and here's where this research is, bam, Supreme Court ordered oral argument within days. Only about 80 cases that go to the Supreme Court, and there are tens of thousands of them every year. Number one, make it to where the Supreme Court even looks at the appeal, and only 80 of them get set for oral argument, with Hunter v. U.S. being one of them. It is impossible to explain how important this case is. If the U.S. Supreme Court agrees with Mr. Hunter and with the organizations that filed, every one of those amicus briefs are in favor of Hunter. No one filed an amicus brief in favor of the United States, to show how many different groups want to see change in this area. Oral argument is scheduled. That is a hearing, Tuesday at 10 a.m. And you're able, if you can, to listen to it live. There's no courtrooms, cameras in the courtroom at the United States Supreme Court. That does not happen. But they live stream so you can listen right on their website. If you can't listen live, it will be on their website so that you can listen to it on repeat. Or if you listen to it live and you want to listen to it again, as I think I will be doing, you can do that as well. I plan on having a live on Tuesday evening after the Hunter oral argument, after I have an opportunity to digest it, listen to it at least one more time, live, then on repeat. And then I'm going to come on here and give my thoughts. But I want to hear your thoughts, because your thoughts mean a lot to me. I read every comment everyone puts on our YouTube channel, on our podcast. And by the way, the podcast it's on Spotify, but it goes to a number of other podcast hosts. I like the YouTube host because the YouTube host has a search engine. There's almost 1,000 episodes right now, 1,000 episodes on Idaho versus Kohberger podcast, but there's no search engine on Spotify, on iHeart, on Apple, on some of the other places where you can listen to the podcast. YouTube has a powerful search engine. So if you want to pick up all the episodes that deal just with IgG DNA, you put that in the search engine on YouTube and it's going to pull them all up for you. And then it will tell you, here's where, if you want to see the motion to suppress IgG DNA that was filed in 2023 in August by the defense, it will tell you where on the docket you can find that piece of paper so you can read it for yourself. If you want to read about, hey, how the heck did this case ever get transferred to Ada County from Leda County? How did Judge Hippler ever even get involved? These crimes didn't happen. Alleged crimes didn't happen in Ada County. They were in Ada County, in Latah County. Well, plug in the search term on the YouTube channel, motion for change of venue. That was a motion that the defense asked to get out of Latah County because of prejudice, extreme pretrial publicity. And that was on January 30th, 2024. Without that filing, this case would have probably remained in Latah County. And Judge would have probably sought through. Maybe there would have been a plea deal. Maybe there wouldn't have been. Who knows? It just seems like Judge once in a while, he granted defense motions. Judge Hippler rarely granted defense motions. And some people think that may have had something to do with why this plea deal was even entered into. We cannot know the answer to that, because going back to what the amicus is saying in Hunter versus U.S., these secret plea deals are a problem because the public doesn't know what the heck motivated it, who said what was offered, who approached who, because it's done behind closed doors. Hey, Saber Super Sleuth Tagger, we're having a great day. Thanks for being here with us. Yeah, Carrie, when I saw that, I said, uh-oh. How many was it? 28 calls. Yeah, a lot of discussion. But the problem here, Blueberry, let's recall the events of July 2nd, 2025. Didn't Judge Stephen J. Hippler, or did he not, turn to Ms. Taylor at one time and say, did your client receive all of the discovery that he needed? And she said yes. She said yes. My client had all the discovery he needed. to enter into this plea deal. Now, something is not connecting here for me, which I wish we had access to these plea negotiations, because didn't Ms. Taylor stand up in open court time and time again, going back to Latah County 2023 days, and say that she was not getting discovery, or not getting it? It was like a needle in a haystack. It wasn't organized. And her client was suffering as a result, with the trial date getting closer and closer and closer and closer. She stood up in open court. He asked her that question. I think he asked her that question for a reason. Did you receive all the discovery you needed? She said yes. I'm glad that you're here, Saber. Thank you. Thank you for being here. Oh, okay. Carl, put Tuesday, it's probably going to be somewhere around 6 or 7 p.m. Eastern Standard Time in the United States, because oral argument is at 10 a.m. on Tuesday the 3rd. And I, quite frankly, I'm going to have to watch it live. And I know I'm going to have to watch it a second time to make sure that I'm getting everything. Now, do not expect, and I do hope that you'll be able to watch live if you can, or at least watch it on replay. But don't expect a ruling on March 3rd. That will not happen on Tuesday. That's not how it works. The ruling on Hunter versus U.S. as to whether or not there will be additional grounds for parties like Mr. Hunter, like Mr. Kohberger, and so many others to be able to file appeals, despite the fact that they signed on the dotted line that they would not appeal their sentence as part of their plea agreement. Will more categories of reasons be added, like due process, like a fair and impartial judge, like a bona fide opportunity to be heard? That's all part of due process. Or is the Supreme Court going to say, no, you sign your name on the bottom line. It is a contract. It's no different than any other contract, unless you have an effective assistance of counsel or the judge sentenced you to more than the statute required. You need to stay put. If that happens, then there's no change in anything. And I, for one, have been wondering if this is the reason why we have not been hearing anything from the defense side. Remember, once that gag order was lifted, the state, their experts, law enforcement began talking publicly. Celebrate, they began giving interviews publicly. Othram, didn't they go to CrimeCon? Right? Then we saw everyone from the prosecutor, Detective Payne, members of the Idaho State Police give a big press conference right inside the Ada County Courthouse. Even while probably Mr. Kohberger was getting ready to be transferred from the jail to the prison. They didn't even wait to leave the courthouse. They gave an interview, press conference, inside the Ada County Courthouse, January 23rd, 2022. What about the defense? Has anyone recalled seeing any interviews that Ann Taylor has given, Cy Ray has given, that any of the other investigators, any other members of the defense team gave? Not a word. As a matter of fact, Ms. Taylor put out a notice signed by the other defense attorney saying, don't ask. We're not going to be giving any public statements. And Mr. Kohberger has been very silent as well. Is Mr. Kohberger just accepting what that sentence was, or is he waiting for March 3rd to happen. Because this hearing, even though you're not going to get a ruling on Tuesday, it's not happening on Tuesday. The Supreme Court has to put out a well-reasoned opinion, and it will tell you 5-4 in favor of Hunter, 5-4 in favor of the government, 8-1 in favor of the government, 8-1 in favor of Hunter. They're going to talk about what the issues were, that this is a matter of appeal waivers. And what are the reasons that would allow a defendant who has signed a plea agreement and agreed to waive appellate rights? On what conditions could they somewhere down the line in future be able to appeal and seek a new trial? Because that's what an appeal would do. That's what an appeal would do. His other option, as we've said, would be basically you'd need the governor of the state of Idaho to issue him a full pardon. So at this hearing on Tuesday, I recommend that if you're listening live or on repeat, pay close attention to not what the defense is saying, not what the government's saying, not what Hunter's attorneys are saying. Pay attention to what the justices are saying. What you're going to see is, because this is not the government's appeal, this is Mr. Hunter's appeal, his attorneys are going to speak first. Then there may be some questions from SCOTUS. One or more of the justices may have questions, may seek some, well, what do you think about, doesn't the Fifth Amendment say this? And what about, why is this any different than our decision in Garza in 2019? And why isn't this a contract? And why, you're going to, and based on their tone and what they're asking, I think that we're going to be able to get some good feedback into how they may be leaning. Because remember, they've read everything. They've read the petition, the response, and the reply from the parties. They've read all of the amicus briefs. It's not like they're coming in for the first time on the 3rd and they're hearing this for the first time. Not at all. So they got their questions possibly written down. They may ask for clarifying information, or they may make some comments that will give a clue. And that's what I'm looking for. If I'm doing anything on Tuesday, it's not to listen to Mr. Hunter's attorneys argue their position, or the government's attorneys arguing theirs. I've read all of them, plus all the amicus briefs. I know where they're coming from. I want to hear what those 9 justices have to say. And that's what I'm going to be taking notes on. And that's going to be the principal discussion for Tuesday. And I'd like you to also give your opinions as to how you felt things went. Because a lot of times, even in the Kohberger case, it was not really difficult a lot of times to figure out how Judge Hippler was going to rule. Alternative perpetrators defense, he made a couple of comments in the public portion of it. And what he wrote, it looked like that was going to be a big fat denied. And it was. So what the judges say, remember, this is a panel. It's not just one judge. It's got to be, we need a majority of them. We need at least 5 of them to rule in a certain way. Now, sometimes there'll be a justice of the Supreme Court who's not there that day. Maybe there's an illness. They're people just like everybody else. And then there's only 8 as opposed to all 9 who will be there. Then you need a majority of the 8. Whatever 9, you need a majority. However many are there, you need a majority. It doesn't have to be unanimous one way or the other. What you're going to hear first, it will be the Chief Justice of the Supreme Court who will call the matter to hearing. And then it's going to be turned over to Mr. Hunter, his counsel. Hopefully we'll get some questions, follow-up feedback from the justices. Then it goes back over to the defense. Remember, The government, they're winning at this point. They won. They don't want this appeal waiver to be expanded to include more reasons. Fifth Circuit already shot down Mr. Hunter's request. That's the Fifth Circuit Court of Appeal that is over Texas. Said, no, you're not getting an appeal. They're winning. So they respond, and then there will be a reply. And I think we'll know by the time that hearing is over how this ruling that will come down may. Again, no guarantees, but may be. Those are important clues, what those justices say. Jurors asking, do you believe it's possible that public outcry can free someone who makes a plea when the public gets to see for themselves that the evidence doesn't? Under our system of government, there's basically right now, unless that would be something to convince the governor to do something about it, this is really the other hope. You would need to do it through the appellate process and win in a court of law the right to a new trial. Oh, of course, this is why, George, this is why this hearing is so important. Blueberry is saying the sheath, the only piece of evidence that they have wasn't even sealed, and there is no chain. I agree, Blueberry. I've never understood why the defense didn't move to get that sheath thrown out in limine. I don't understand. There were so many holes in that journey from Moscow, from 1122. It was collected by, remember who did the crime scene processing? The Idaho State Police processed the crime scene, bagged certain pieces of physical evidence, including the sheath, and it was turned over to Detective Payne shortly after midnight on Monday the 14th. And from there, we don't have a chain of custody. The next thing that we know that we're able to verify is that the first of two ISP corporals went to the Moscow Police Department the morning of the 16th of November, collected that sheath in its sad, sorry condition. As far as I'm concerned, you don't have evidence tape. You don't have initials. That's not good enough. That's a problem. And then en route, he didn't even go all the way to Meridian. He turned over that sheath to a second ISP official. En route, he turns over this critical piece of evidence. And when it turns up at the ISP lab in Meridian, only the second ISP official's name's on that chain of custody, not the one who picked it up in Moscow. It's just the second one. I want to know who gave the authority for the one who picked it up to not take it all the way to Meridian. When Sergeant Blacker was charged with taking the DNA profile that ISP worked up from Meridian to Houston, Texas, and onwards, he didn't turn it over, the profile, over to anybody. He's saying that he had his eyes on it every step of the way, and it had evidence tape on it. It was secured. That's in Blacker's report. It was secured properly. I'd like to hear what Blacker had to say about the condition of the sheath when it left the Moscow Police Department, and why, if they knew that only one person could take the profile, why the sheath that gave rise to that alleged profile was handled the way it was. I will never understand why they didn't move to strike that sheath. But that is all water under the bridge. Maybe we'll know more when the case continues to be unsealed. Who knows when that's going to happen? And all we can do at this point as the public is to bear witness to what happens on Tuesday. The ruling will come down on or before the end of June 2026. Is there a possibility it might be in April or May? Yeah, there's a possibility it could be that early, but it cannot go beyond the end of June because that's when the Supreme Court then closes shop for the summer. And then they come back the first week of October to commence the 2026 to 27 year. And that's when a bunch of new appeals start getting filed, and they do, like they did with Hunter. They start deciding, okay, well, this one, yeah, this one, no, okay. No, we're going to pass. We're going to pay. Most of them are passes. Again, only 80 of the ones that were filed for this year, the 25-26 year, made it to oral argument. Hunter is one. Any questions, comments? Let's hope that they find the grounds they need for Hunter's plea deal to be overturned. Well, we're going to find out very soon here, Joe. We're going to find out on Tuesday. Real important information regarding if Hunter is going to be successful or unsuccessful. So please pencil in on your calendar to be with us on Tuesday if you can. It'll either be 6 or 7. It depends really on how long oral argument goes that morning and how complicated it is and how much feedback is given so that we can have a quality discussion per the First Amendment. Yeah, 100% Blueberry. You can bet your bottom dollar Taylor is still getting paid. Oh, yes, she's not working for free. She's not pro bono. She never was. She was being paid through whatever her public salary was when she was the Kootenai County head defense attorney. And then she went out on her own. There was an hourly rate that she was being paid. She's being paid for her work on this case still. Same with the prosecutor. He gets a salary. He doesn't do his work for free. All right. How can we be of help? Keep talking about the case, Carl. Keep talking about the case. Write to your representatives, your Congress people. Let them know you have a real concern about the First Amendment and you're concerned about the precedent, if that's how you feel. Not to put words in your mouth. First Amendment gives you the right to petition government for grievances. If you feel aggrieved over what's going on in this case, that you don't want to see another case. I don't think we can stand more cases prosecuted like this in the complete dark. Quadruple unaliving, a DP case. Okay. Oh, Beauty Way is looking forward to seeing Mr. Kohberger take the stand. That might be down the line. I think Blueberry, you made a comment. You're thinking, he's keeping his mouth shut to make sure that he stays safe in prison. Prison is not, from what we understand, look at what happened. I mean, it's supposed to be a high security prison. And within days of him being booked into that jail, or that prison, they had video of him. Somehow someone got in contraband. It looked like it was some type of a cellular phone or something that recorded him in a cell and got it out, and it hit the media and it hit social media. How'd that happen? Whatever happened with that case, I reported on it back in, what was it? It was like September, that the Idaho Department of Corrections said, we're looking into this. We take the safety of the inmates, our staff, and everyone else at the utmost of concern. And hey, there might be criminal charges coming out of this. First and last thing that we heard, that went into the circular. There hasn't been a word since regarding how in the heck was a prisoner in supposedly a high security prison photographed within days of his admission. Thank you, Catherine. Oh, my pleasure, Sabres. Stay tuned. Everyone, if you can, please hit the like button. And also, if you haven't subscribed to the channel, please do so. We're trying to get our word out regarding Hunter. If you look at the description to this podcast episode, I put 2 addresses in there. One is to the Hunter versus United States playlist that we've assembled. We've looked at all of the documents on the court docket. We've told you what the date is. We've given you a synopsis of what it says. And then you can go out onto the other address that I provided you is the link to the United States Supreme Court for the Hunter versus U.S. case. It's docket number 241063 U.S. 2024. Why 2024? Because it was filed April 9th, 2024, at about the time that Mr. Kohberger was getting ready to enter Judge Hippler's courtroom for oral argument, marathon day, motions in limine, still under seal for the most part. All right, everyone. Thank you very much for joining us this evening. Please join us. I'll be putting out an invitation for Wednesday evening shortly. Please hit the notify me so you'll get a notification when that is. I think I'm going to start with 7 p.m. Eastern Standard Time. Thank you, Rachel, for being here. You've been a tremendous support. I can't thank you enough for supporting me in my work. Hit the notify button so that you'll receive a notification and then join in the conversation. All right, that's what this channel exists for. It is to induce First Amendment-based conversation amongst the public. So please comment on the videos, talk to other people, even if you don't agree with their viewpoint, discuss the documents, and you might learn something, they might learn something. And, that's how the First Amendment was created, to induce these types of conversations about things that are important to people. All right. Thank you, Joy. I appreciate it. Thank you, everyone. Have a great night. We'll see you Tuesday. Okay. Thank you, everyone. Bye.